All right, good afternoon, everyone. My name is Alexis Alvarez, for those who do not know me, and I am the Director of Statewide Training at Florida Legal Services. I'm really excited today for a couple of reasons. One being I am giving the presentation today, which is a little different than what we normally do. And two, we're talking about my absolute favorite subject, which is criminal law. So for those of you who don't know about my background, I started off my career out of law school as an assistant public defender in Miami-Dade County. And I did that for 5 years. After that, I transitioned into Florida Legal Services in the prisoner rights unit that we have here. And then I became director of statewide training. So my bread and butter, my passion is criminal law and criminal justice. Which led me to develop this training here today. I know that most of you don't practice in the criminal sphere, or I may be making assumptions, but most of you, I assume, don't. So I know that training on criminal law might not seem directly relevant to your practice, but the point of this training is not to bring you up to speed on all things criminal law so that you can go out there and become a criminal defense attorney. It's really to try to highlight what issues arise in criminal cases that affect your legal aid and public interest clients, and sort of to discuss these things on a very sort of basic level, just so that you can be a part of the conversation. So thank you all for being here today. As always, thank you for what you do in our legal aid and world and our public sector sphere. And thank you for being brave to jumping into Anatomy of a Florida Criminal Case, Essential Insights for Non-Criminal Lawyers with me. So very quickly, I want to just do some housekeeping. First and foremost, you might see a couple different boxes on your screen. That is because one, I am sharing my presentation from one screen. I am looking at you on a different screen. I have Brianna with me from Florida Legal Services, who is assisting me on some back-end tech. And later on in the presentation, we will be joined by Cindy Huddleston from Florida Policy Institute. So there's a lot of different boxes that you might be seeing. That's what they are. Additional housekeeping matters. This is being recorded. A copy of the recording will be sent to you all via Zoom within 24 hours. You can always email me if you don't see that recording in your inbox. And I will ask if Brianna, you can drop my email into the chat. That way folks know exactly how to get to me. Secondly, I usually provide CLE accredited training to you all. This will be approved for CLE credit. The application is still pending. For those of you who know me, I always get my CLE credit, so it will come down the line. I have each of your email addresses saved in the registration, so I will personally email you all that CLE credit code once I receive it back from the Florida Bar. Which brings me to my third piece of housekeeping announcements, which is public interest lawyers, and those of you who are interested in being a part of a community of public interest lawyers. This is being co-sponsored by PILS, the Public Interest Law Section of the Florida Bar. Great organization that I am a part of, and I certainly recommend joining if you are looking to be around other like-minded folks in the public interest sphere. So that link was actually just dropped in the chat by Brianna. Thank you, Brianna. Anyone who is interested in joining, please check it out there. Two more pieces of housekeeping. One, I mentioned that Cindy Huddleston from Florida Policy Institute will be joining us at some point to talk a little bit about our criminal law and public benefits and the intersection. And the last piece of housekeeping announcements are your questions and answers. I'm in the virtual vortex in two ways now. I'm hosting and I'm speaking, and I want to hear from you all. I totally get how weird this is. I'm talking to a box. I think I'm looking at myself. It feels like a weird world, but I feel connected to you all, and I want you to ask your questions, no matter how small you might think that they are. There's going to be a lot of information here, and depending on how much criminal law experience you have, some of it might be clear as mud. So don't be afraid. Drop your questions into the chat or the Q&A, and I will address them at the end. I will gladly address them at the end, as long as you want to stay with me, because like I said, this is my absolute favorite thing to talk about. And so I am going to move into the content and keep track of my time. moving into the first slide that we have here, I have a little bit of a poll, and I'm going to try to launch that poll. Let's see how successful I am. All right, I'm hoping you all can see it. Just quickly, so I know who's in the audience, please describe your criminal law experience. You'll see there's a couple different categories there. Only know what I learned in law school, know a bit, I've handled some cases, I know my stuff, I've handled many criminal cases, and I put a separate category for my current and former public defender or state attorney crew, because that's a whole different level of knowledge. And so I'm going to give it a few more minutes. All right, I'm going to cut it there. And I'm not going to share the results, not necessary, but I will say what I see here is that we have mostly folks who are here and only know what they know and they learned in law school, and they know a bit because they've handled some criminal cases. So I so far don't have any public defender or state attorneys, and you know, more people have done more and more criminal law. So that is probably a good thing for me, because I might get called out on things, you know, if I might not know something. So thank you all for responding to the poll, and thank you all for being here. Let's move into that content on one of my computers. Okay, so first slide, I just want to give you sort of an overview and learning objectives and agenda. Here we're going to talk about this basic structure. We're going to talk about arrests, pre-trial and trial, disposition spelled incorrectly, but spelled correctly probably on another slide. And, you know, we're going to have sort of a discussion afterwards about how criminal cases can affect a person's public benefits. So this is sort of just the trajectory of what we're going to be talking about. It's really going to be basic substantive overview of arrest, general knowledge, sort of talking about pretrial, so you have familiarity about the basic court procedure and process when charges are filed. Dispositions, I know we're all scared of that adjudication withheld, so don't worry, we'll get there. And like I said, at the end, talking specifically about public benefits and the effects to your public benefit clients. Disclaimer, as always, this training will not cover anything related to federal court, juvenile court, death penalty cases. I say that because those are all incredibly niche differences and different sort of spheres. And I just want to be very clear, we're focusing on Florida state court, misdemeanors, felonies, and that's about it. This will not teach you everything you need to know about Florida criminal law, and it will not fully prepare you to handle a criminal case. Again, these are the essentials for lawyers who don't practice in criminal law. So our first slide that we have here is a fancy tree that I created for you all, just to sort of understand the general life cycle of a criminal case. I put some terminology in the corner in case anybody's not familiar. But all criminal cases start with an arrest, and from there it can branch off in a couple of different ways. Going towards the side that says charges not filed, an arrest can happen, charges can never be filed. State might never file charges, and we'll talk more about what that means. And from there, if the state never files charges, they can, you know, file at some point or just never file. It's pretty simple. On the other end, after an arrest, if charges do get filed, you have really three things that can happen. KNP or KNA, you'll see the terminology down there. The state can either no action or null pros a case. That means dismiss it, and we'll talk more about that going forward. Trial can happen, or a plea can happen. And then obviously based on whether or not a trial happens or a plea happens or a dismissal happens, this is sort of where it can branch off. And I just really all I want to note on this slide is unless charges are being filed and dropped or never filed whatsoever, the trajectory is pretty much the same. Trial, if you see, will branch down to either guilty or not guilty. Plea will branch down to your withhold or your adjudication. After that comes your sentencing, which is really, those are the only options: community supervision, jail, prison, credit time served, or a combination of community supervision, jail, prison. And same as back to trial. If you go to trial and you're found not guilty, great. You are found guilty, you're right back to where you are with the plea, the withhold or the adjudication, the community service, the jail, prison, credit time served, or a combination. I know this is a lot right here. We're going to unpack that moving forward through the rest of the presentation. So arrest. Why am I starting with arrest? Well, all criminal cases have to have an arrest. It's just a necessary component and really the beginning. And here, talking about arrest, I want to give you sort of that black letter law, a little bit of a reminder of law school, sort of what the legal standards are, but very, very briefly, because I want to move into really what happens after an arrest. But in order for somebody to be arrested, the legal standard is probable cause. And that probable cause must be proved by a preponderance of the evidence. I'm sure you all are familiar with preponderance of the evidence, mostly being in the civil sphere. As you know, it's 51%, in some terms to say it that way. And probable cause is not defined by statute, or not by pure definition. It's defined by case law. And a definition that I found here is a reasonable ground of suspicion supported by the circumstances, strong enough to warrant a cautious person to believe that the named suspect is guilty of the charged offense. A lot of verbiage, but I wanted to put that definition there to really show you it's not much. Probable cause is really, a cautious person to believe that somebody did something based on some reasonable circumstances, right? And so I jumping back up to the top of the slide, this can be established in a few ways, by sworn complaints, affidavits, depositions under oath. Most commonly, it's usually, an officer who drafts an arrest affidavit based off of what they've investigated or they've viewed in their own plain sight, saying, based on their attestation, that this incident that they witnessed rises to the level of probable cause, thereby warranting their arrest of an individual. The rules that are relevant to probable cause and arrest verbiage are there. And the other thing I wanted to make note of is a promise to appear or notice to appear. Some of you in the civil world may come across this. It's not incredibly important, but it's worth noting. You can actually be arrested without ever having handcuffs put on you. That is something that people get confused about. Have you been arrested? Have you not been arrested? Well, I never was taken to jail. I never got booked. Just to keep an eye out, it could be a promise to appear or a notice to appear, which for some lower level crimes, police officers have the ability to, instead of booking someone or putting cuffs on them, give them a little piece of paper that says you need to come to court on XY date in order to address your case. So I thought that was important for those of you, especially maybe practicing in legal aid, when you're talking to a client and they say, well, I've never been arrested, but I had a criminal case. You have been arrested. Whether or not you actually had handcuffs or were put in jail, different story. So just wanted to at least note that. But arrest requires probable cause. Probable cause is reasonable suspicion supported by the circumstances. Now, which brings me, if anybody is remembering law school again, to reasonable suspicion. Well, you have your arrest. Some criminal cases will start maybe with an investigation or maybe an investigatory stop, right? Like somebody is stopped because an officer maybe saw something that was suspicious, and that officer is now going to try to confirm their suspicion. Going back to the other slide, try to find those circumstances that support their reasonable suspicion. I wanted to note here that investigatory stops, reasonable suspicion are not formal arrests, but they are certainly a form of detainment that infringe a person's liberty, so it's not to be taken lightly. The legal standard here is, again, reasonable suspicion, which Florida actually has its own stop and frisk law. I don't know if many people are familiar with that, but the statute that governs is there, 901.151. And without trying to read this entire definition to you, reasonable suspicion is when a law enforcement officer encounters circumstances that reasonably indicate that a person has committed, is committing, about to commit a violation of the law. They can temporarily detain that person in order to ascertain their identity, understand what's going on, what the officer is seeing really what he thinks it is, right? So some fun examples, and this is really going to be the only law school type the slides. These are only going to be the type law school type slides in this presentation. But I always like it. When does reasonable suspicion become probable cause, vice versa? If you can't tell, criminal law was my favorite in law school. An example that I always put on there is marijuana. It's a pretty easy example to understand. This case is a juvenile law case, actually, but the law is consistent in juvenile and adult criminal cases. So this says there is probable cause to arrest a person based on the particularized odor of marijuana. Now, why do I say that? So an officer may be walking around, maybe they're at Rolling Loud, maybe they're, just walking down the block, and they smell marijuana. They don't know where it's coming from. They can't attribute it to a particular person. They just smell marijuana openly. That is not going to be probable cause because it's not particularized to a person where an officer can say, I have reasonable belief to believe this person is smoking marijuana. And I have confirmed that by the circumstances because I smell the odor particularly to that person. The case of JJ is really actually a group of kids, and they're all there's an odor of marijuana coming from the group of kids. So the officer arrests all of the kids, and the court there said that's not enough. This officer needed to identify which child in particular was the child smoking, or if they all were, how does this officer know that with particularity to that person? So I bring that up because I think it's a really fun example and very clear in my eyes. If it's not clear, drop your questions in the chat. Always happy to reopen this conversation at the end of the presentation. Another example is your DUI. Somebody's driving a vehicle. Maybe they're driving a little recklessly, or they ran a light, or the officer thinks that there's something going on. There is an infraction, right? Because an officer can stop for running a red light or an infraction. And they pull that person over. And once the window opens, they smell the odor of alcohol. They see bloodshot eyes. Let's just make it easy for this circumstance. There's a bottle of tequila open in the car. That reasonable suspicion where maybe the officer thought this person might be drunk driving, but I'm going to stop them for running this light because they ran the light, but they also might be drunk driving. Reasonable suspicion. Once those other circumstances come around, the open tequila bottle, the odor of alcohol, the bloodshot eyes, just for this, let's even make it simple. The driver says, I'm wasted. I'm just going to try to make it simple for this conversation. At that point, the officer develops probable cause based on that reasonable suspicion, supported by the circumstances that elevated the reasonable suspicion to probable cause. So the point of all that being, reasonable suspicion can be dispelled by an investigation, but it can also be confirmed and rise to the level of probable cause. And why is that important? Because all criminal cases, whether they start with reasonable suspicion or they start directly with an arrest based on probable cause, involve an arrest. So moving over to the next slide, I think I said this, I'm sorry, but the takeaways being all criminal cases involve a formal arrest. An arrest requires probable cause. And I think most importantly is an arrest alone does not mean that the accused actually committed the alleged crime. And I find this really important to say because we often conflate arrest with whether or not somebody actually did something. And going back to sort of the beginning of this conversation about arrest, we're talking about probable cause and really how low that standard is. Probable cause is preponderance of the evidence. Just a reminder that an arrest does not mean that a person actually did what they are alleged to be doing or have done. Which brings you to my favorite slide that you'll probably see a few times throughout this presentation. I'm sure you all have heard, all people accused of a crime are innocent until proven guilty in a court of law. I was taught as a young criminal defense attorney, and really just is where my heart and my mind align on the rights of people accused of crimes. It is not that people are innocent until they are proven guilty. It is unless. And I say that with utmost importance because if we begin our thought process about people going through the criminal justice system as just waiting for that conviction to come, until they're proven guilty, we've already lost sight of what's going on in the criminal justice system and how it's supposed to be viewed. You're innocent unless proven guilty by a court of law. So moving on and checking my time, because I can talk about this stuff forever. What happens next? So when a person is arrested, the law enforcement agency will then forward that arrest affidavit to their jurisdiction state attorney's office. And the state attorney's office will then get involved and consider the formal charges and whether they'll be filed in court. Now, I'll back up and say there are a lot of nuances. I'm not talking about your case where there's been like a drug investigation on a house for, months that the state attorney's already been involved, the detective. There's always a little bit more of more nuance. I'm just talking about your basic, an arrest happened, this is what's happening next. There's always more layers to different parts of the criminal justice onion. So our next slide is going to talk about the first stages in the criminal justice system if you're arrested. I say if you're arrested because it doesn't mean charges are formally filed yet. So the law enforcement agency has made the arrest. They've forwarded the arrest affidavit to the state attorney's office. And the first thing that will happen is your, well, not your client, but the defendant will have their first appearance, and then they will have their arraignment. These are really the two most substantial court dates that occur before trial is ever set. So first appearance. What's happening in first appearance? It's also referred to as your bail or your bond hearing, which I'm sure many of you have heard about as well. And this really comes from the fact that those who are accused of a crime have the right to appear before a judge 24 hours after their arrest. And the rule that governs that is there. And what happens at your first appearance? Like, what's going on? So first and foremost, formal charges are still not necessarily filed. Sometimes they are, but most of the time they're not. The court is reviewing the arrest affidavit to determine whether there is probable cause for the charges that are alleged. So an example being if there's an allegation of burglary, and that's written into the arrest form, which is just a document that a police officer types in or writes what happened. When you're looking at that arrest affidavit, are there the elements of entering in to a structure or a dwelling without the permission with the intent to commit a crime, right? And so probable cause, that original probable cause that we talked about back when the police officer is making the arrest, is now being reviewed by a court. The court is saying, okay, officer, you arrested this person. This is why you arrested this person. Now let me look at it so I can determine, one, if that seems like a probable arrest, if you had probable cause, and two, to determine what are we going to do with this person? Are we going to release them back into the community? Are we going to hold them in jail? What are we going to do? They're going to address the conditions of release. Another factor that's important is, at this point, if there's a victim involved, if it's a case that maybe has more special nuances, the court will issue a stay away order from the alleged victim or a no contact order. And that can get messy because sometimes family members, are alleged victims, and people live in homes sometimes with the same person, the alleged victim. And sometimes the alleged victim doesn't want a stay away order. Sometimes they do. So all of this stuff can get a little difficult, but this is where all of that stuff is preliminarily addressed to ensure that the officer was correct, at least about their thoughts. It's probably not the right way to say it, not correct, but there was probable cause to support the arrest, and what we're going to do with the accused now that we have an arrest supported by probable cause. Something I put here too is if probable cause is not found, if the judge is looking at the arrest affidavit and says, I don't think this cop had enough. I don't think this officer told me enough about why they arrested this person. There's no probable cause. The state can request a reset to the next day. Sometimes I've seen it happen for a week in order to get the officer in order to add to that arrest affidavit through their testimony to tell the court, even though I didn't write it in my arrest form, this is also what I saw, so that the court can then decide what to do about the arrest and what to do about the release of the person. Okay, so bond hearings. I thought this was important to talk about because I know a lot of us in the civil world end up having clients that are maybe out on bond or experiencing bond issues, and it seems like a foreign language. So Florida statute chapter 903 applies to bond hearings. And I know you're probably thinking bond, bail, what's the difference? I know in some states and some other jurisdictions, bond and bail do mean other things, but according to Florida statute, it specifically says that bail and bond include any and all forms of pretrial release. So bail doesn't just mean money, bond doesn't just mean other things. It means the same thing, according to Florida statute. And the purpose of bail in a criminal proceeding is for two reasons: to ensure the appearance of the criminal defendant, want to make sure the criminal defendant comes back to court, and two, to protect the community against unreasonable danger from the criminal defendant. Okay, let's see if my slide catches up with me. All right, so at a bond hearing, what is the court considering? Now, I want to also just remind us, bond hearing is first appearance, same thing. We're still in that world of the first time that an arrested person is coming before a court. The court is considering whether there's probable cause within the four corners of the arrest affidavit. So that's a document that the officer writes things down and says what happens, the nature and the circumstances of the offense and the penalties and the weight of the evidence. So if we're talking about, a petty theft or a robbery, if we're talking about, these things, priors, a person's prior criminal history. And sometimes the state attorney has the out-of-state priors. Somebody might have prior convictions from a different state. If the state attorney has those at the bond hearing, the court is going to look at those. And the same when it comes to their in-state priors, any prior cases, convictions, or open cases that they have in their current state or jurisdiction. And like I said, any other open cases, including probation, misdemeanors, things like that. The court is also considering whether this person is a danger to the community. As we said on the last slide, the purpose of bond, one of them is to protect the community. Is this person a danger to the community? And it's a contentious kind of conversation. Again, with a disclaimer, I'm a former criminal defense attorney and public defender. So, I think sometimes certain things don't indicate danger when other people might think that they indicate danger. And I will say also, I guess as a disclaimer for that, I may throw around the term robbery or murder or things like that. I'm not going to get into any details, but I just want to put that disclaimer on there that we are talking about criminal law, and I may throw some of those terms out. If any of them are triggering to you, please feel free to step away and come back when you can. I probably should have said that earlier, but danger to the community, some people will say it's priors, the types of priors, whether or not the person has access to firearms, whether the person some people find mental disabilities to be dangerous. There's a lot of factors. Additionally, the court is considering flight risk and whether the person has substantial ties to the community. Why? Because again, part of the reason of bond is to secure the appearance of the defendant at trial. So if this person has ties to the community, a family, a job, the court views it as they're less likely to run away from trial, right? Interesting thing about being a public defender out of Miami, during spring break and the holidays, we usually get an uptake in certain types of crimes, and it's from spring breakers or people who are on vacation. And in those situations, the court sees that the person has no ties to the community. They're just in Miami for the weekend. So they're less likely to just release them because they don't know how to secure them back for trial. They can't exactly get the person back from another state down that easily in state courts, not federal. Anyway, court is also considering source of funds. Not as much of an issue in our more, our lower income client base, because the funds are obviously an issue, if not non-existent. But in your, more white collar crime or your attorneys, your private cases, your private criminal defense cases, Source of funds is something that's considered. For example, if someone accused of a drug ring, selling drugs, is able to bond out at a high rate because they have a bunch of cash, the court might say, where's the cash coming from? And then that defendant would have to show that the money is clean. And that could trigger a nebia hearing, which is that hearing where the judge determines if the money that the person is using for their bond is legitimate. And then, of course, there's a catch-all. That would be any other relevant factor. The court can really have a little bit of discretion here to decide why they might want to release someone or not. So the next slide I have here for you is just an example of an arrest affidavit. Again, I got this offline, totally public record, not a former client. I'll put my disclaimers out there. And I wanted to just show you this to give you an idea of, this. I wonder if I can use my mouse. Probably not. Oh, is that my mouse? No. Well, anyway, the narrative is the part towards the end where you can see I was on my routine patrol in my marked vehicle. Up towards the top, you'll see there's DWS with knowledge or DUI. Those are the charges. Obviously, you have your biographical information higher up on the screen. And, oh, there's my mouse. Okay, sorry. Here's the biological information. Here are your charges. Here's the narrative. This is actually a narrative of 3 pages. You see 1 of 3. I only put the first one here, but this is what the judge is looking at when they are making a determination of probable cause and determining at a first appearance and looking at the bond conditions. So the other thing worth mentioning here is the types of pretrial release. You might have a client that comes to you and says, I'm ROR'd. I got ROR'd from court. I didn't have to pay any money, but I'm on bond, right? Things that might seem a little confusing. So these are the general types of pretrial release that exist. Again, we're talking about Florida State Court. Somebody can be released on their own recognizance, which is sort of your gold standard. It's no money, no conditions, no supervision, go back to the community, come back for your court date. Then you have your non-monetary bond options, for people who are not able to afford monetary bond issues or options. And every place is a little different. I know in Miami, we had the pretrial release program. We also had the TAP program, which was for people experiencing homelessness. And these are non-monetary bond options for people to be able to report on a weekly or daily or whatever basis that's required. That way the court can keep track of them and make sure that they are going to come back to court. Monetary bond, pretty self-explanatory. Ultimately, monetary bond is a money amount that is attached to a type of charge. There are bond schedules that tell you really like what a type of a charge a standard bond is. And just for those of you who don't know how the bond process works, if you get a bondsman, if a person is going to outright just pay their bond, they're going to pay the full amount. So if I was arrested and I had a $10,000 bond and I wanted to bond out and I didn't want a bondsman, I would have to pay $10,000 to get out of jail. If I hire a bondsman, I would pay that bondsman 10% of the bond. That bondsman would then post my bond and be on the hook for the entire bond amount if I fail to appear at court. So there's the extra security of a bondsman. Sometimes courts want a bondsman around because they know that the bondsman might be staying on top of the defendant so that the bondsman's not on the hook for the full amount of the bond. So $10,000 bond, you get a bondsman, you pay the bondsman $1,000, bondsman posts your bond, you're out. And if you miss court, you're going to have a very unhappy bondsman. House arrest. People are often on house arrest pending their charges, sometimes for a long time. And all I want to say about house arrest is it's pretty self-explanatory. You're locked into your house. You have to report to a house arrest officer. They check on you whenever they want. There is roaming versus standard, where somebody can be on roaming house arrest, where they don't have to check in with the house arrest officer all the time, but it doesn't happen as often. Standard is basically like you don't leave the house unless your house arrest officer lets you. And I want to say two things about that, because again, remember, I'm a former defense attorney. This is where my mindset comes from. First and foremost, house arrest is expensive. You don't realize that. There's a huge cost when there comes to house arrest. If somebody is on house arrest for 5 years pending a charge, there's a charge every single day for that. And yes, it can be reduced. I've seen for people experiencing, more low income folks, that it can be reduced to $1 a day. But imagine $1 a day for like 5 years. So house arrest ain't cheap. And two, it's very hard to comply with. You cannot leave for anything. And if you do leave and there's an emergency and that's why you left, you're going to get arrested. You're just going to have to show the court why it was an emergency afterwards. So house arrest can lead to this sort of like, I had an emergency, I had to go to work, I had to do this, this is what happened. In and out of jail, in and out of jail. So it's really, really tough. And yeah, somebody just put in the chat, if your electronic monitor inaccurately shows that you left. Yes, thank you so much for putting that in there. Or I've had it where it's died and people are sitting in their home like, what do I do? And you would think, just call your house arrest officer. It's not that easy, folks. They're monitoring a lot of people. But I could also go on about this forever, so I'll move on. But then no bond. There are situations where a person can be entitled to absolutely no bond. There are non-bondable offenses, just some things that are so heinous that you cannot be eligible for bond. Another kind of common example is if you're on probation already for a closed case, and now you have been arrested on a new charge while you're still on probation in the old case, you're likely not going to get a bond, especially if the case that you're originally on probation for is a quote unquote violent felony. You'd be what's called a VFOSC. This is a lot, but we'll get into it a little bit more, and you just will not be eligible for bond. So I talk about this on this slide just so you have some familiarity with your client, that if he or she is wearing a GPS monitor. Why? Maybe they're on house arrest. Maybe they're still waiting for their criminal charges to be filed. This is all still just within the first appearance, 24 hours after being arrested. Other little things to consider with bond hearings, other takeaways. Your motion for bond or modification of bond can be filed by any party at any time when there's a change in circumstances. I think this is important for us who are in the non-criminal world to understand, because we have clients that cycle in and out of custody, and we don't know why. Could be something happened with their case, that a charge got elevated, a charge got dropped. The alleged victim came in and claimed that the defendant harassed them, and then the bond got elevated, or somebody got arrested for a new case, but then that case got dropped, so they can go in and out and in and out. So I just think it's important to understand that just because someone has a bond at one point, that does not mean that's their bond throughout the full life cycle of the case. The other thing that to take away is, again, the legal standard is preponderance of the evidence. That's it. We have so many people sitting in jail based on preponderance of the evidence. So I just think that's important to say. Additionally, the accused has the right to notice and the opportunity to be heard. Can't just set a bond for somebody without letting them know that they're having their bond hearing, because this is a huge infringement on liberty. So the accused has to have notice, which can, come in different letter in the mail, from the clerk of court's office. If somebody's already in jail, they're presumed to have notice, but I won't go into that either, because corrections doesn't always necessarily bring people to court. And opportunity to be heard. The accused has the right to say why probable cause is not established. Now, that brings me to the point that the accused at this point is entitled to an attorney. The public defender's office is likely going to be appointed at first appearance, even if the person might be able to afford private counsel but isn't sure yet, has to, look at their finances. And that's because at this point, that person has a right to an attorney. So the public defender's office will usually be appointed and discharged later on if somebody can afford a lawyer. And also to say the public defender's office will do a lot of advocacy on behalf of people shuffling through their first appearances just to try to get people out of jail, because I will tell you, it's a lot easier to stay in custody once you're forced to stay there from the beginning. And it's a lot easier to be put into custody when you're out. It's really harder, much harder to get out of custody once you're already in. So first appearance is paramount to making sure people accused of crimes are not unlawfully or unjustly held for what they're accused of. Quick eyes on the legislature. Just want to mention that there's a House bill that should be effective in January. It's sort of supposed to have a development of a statewide bond schedule. As you can imagine, in certain jurisdictions, things are not as uniform as they are in other jurisdictions, and some people are held or given higher bonds in certain areas, and obviously that's not fair. So we'll see. Just eyes on the legislature here. Okay, arraignment. And actually, I see a question in the chat. I'm going to try to answer it now. How soon does the accused get to meet with a public defender? Great question. Is one appointed at first appearance, bond hearing, and contact is made later on? So a great question. And so very quickly, your public defender will be appointed right there and then in court. Whether or not your client is there is a different question. So like I said, sometimes corrections doesn't bring a person, or well, if a person's not there, they're going to get a warrant if they're out of custody. But anyway, so to answer that question is you usually meet your public defender in court that day very quickly for 5 minutes. Your public defender advocates as much as possible, and they move on to the next person because there are many people that are represented by that attorney. And then the public defender's office will attempt to schedule an interview, a more formal interview with that client as soon as they can. Every public defender's office has different policies. I know for at Miami, there's, I think within like a week, you're supposed to have an interview set up. And then you get your more formal interview, but you really meet that public defender for 5 minutes in the beginning, in court, and then you have to make those follow-up appointments. So I hope that answers the question. So arraignment. This is another very critical stage. Why? Well, first and foremost, we talked about how at first appearance, charges still have not been filed. Sometimes they are, but oftentimes they're not. Arraignment is the formal time where the state attorney either files formal charges or doesn't. Why is this important? Well, first and foremost, if somebody is accused of a crime, there's an arrest made, an arrest affidavit, probable cause, the court agrees, they've been given their bond. I'm sorry, not given their bond, excuse me. I'm sorry, let me back up. An arrest has been made. The court agrees that, sure, there's probable cause. The state attorney is determining whether or not they want to file formal charges, because the arrest alone is not a formal charge. I want to be very clear about that. The state has to file formal charges based on that arrest. If the state does not file formal charges, by the 33rd day, within 33 days of that arrest, the person is automatically to be required to be released. The court is automatically required to release that person on the 33rd day if the state has not filed charges. And not just release in any way, shape, or form, the gold standard, released on their own recognizance. Now, of course, I put in quotations, unless there's good cause, because that's always the case. If there is good cause, the state can say, hey, I know we're at the 33rd day. We're still investigating this, maybe waiting on DNA, waiting to talk to an alleged victim. We need a reset to the 40th day. It can get reset to the 40th day, but then if the state still does not file charges, mandatory release on your own recognizance. So this is incredibly important because of what we talked about. Once you're out, it's harder to get out once they've already said you have to stay in. So what happens next? So at arraignment, the defendant must be present, but the court can waive the appearance of the defendant. Usually a defense attorney or the public defender will be there in their shoes for them. Formal charges are filed and read out loud, and then usually a plea is entered. That plea is not guilty most of the time. Although there are plenty of times where a case can resolve at arraignment, meaning the state can literally file charges, turn around and say, all right, now we'll offer you this. And you can close a case. A case can start and end all in 5 minutes in criminal court. Public defender will be appointed if not already. And then the defense attorney will do a demand for discovery. It's often just verbal, followed up by like a written demand for discovery. But they say, hey, we accept appointment. We enter, or I am the lawyer. I enter a plea of not guilty, and we demand discovery. And that triggers the state's responsibility to provide discovery within 15 days. And discovery in criminal court, like all litigation, is ongoing. The state has an ongoing discovery obligation to turn over what they get when they get it. And the defense has some discovery obligations that we'll talk about in the next slides coming forward. But then the case is usually set for trial, a sounding, which is like a status, or plea. Or like I said, resolved that day. So kind of just to go, we had our arrest, we had our first appearance where we're talking about bond and release and those conditions. Then we have the arraignment where formal charges are filed or not. Next. Oh, my favorite slide again. I bring this up to say, even if the government files formal charges against a person, they are still innocent. Innocent unless proven guilty by a court of law. Filing of charges is not being proven guilty by a court of law. So pretrial procedures, if charges are formally filed, I'm just going to kind of let you all look at this chart or slide quickly if it will catch up. Okay. All the stuff that's happening between arraignment and trial. You might have, especially if your client is represented by the public defender's office, you may have a client coming in saying, well, they didn't do anything for me. They're not doing anything. They're not working. And I will say there's, in every position, in every profession, there are people that don't do their job. But majority of the time, this is the type of stuff that's happening in the woodworks, in the back, that the client is not exactly aware of, even though they should be aware of. But the reality is, as a public defender, you have so many clients, it's extremely hard to keep them abreast of all of the nuances. But you're setting client interviews, reviewing discovery, setting depositions, negotiating pleas. You're plea negotiating from day one. Even if your client doesn't know it, you're plea negotiating from day one, because when you meet your client, you talk about what they want and you try to make it happen. Filing reciprocal discovery. Defense attorneys are usually responsive. What I mean by that, it's reactive to what the government does, but there are some things like alibi witnesses, defense witnesses, evidence that you are required to be proactive about providing to the state attorney so they can also do their due diligence in their investigation. Lots of continuances, sending public records requests, all of that stuff is going on. And this is just pre-trial, just after arraignment until trial. So I'm going to actually, because I know I'm just having too much fun talking about this. I'm going to try to make it quick here to talk about your right to a speedy trial. But ultimately, the right to a speedy trial is important to make note of because it's a right to the defendant. It's not a right to the government. And ultimately, there are two types of speedy trial rights. You have what's called your naturals, which means a case naturally needs to be brought to trial within a certain time frame, or the case has to be dismissed, or if naturals are blown, which means that the defense took a continuance or they delayed the case in some way, and that natural time frame has been affected by the defendant. The defendant can always file a speedy demand, which is a motion that basically, it's actually a notice. It's not even a motion really, but that basically tells the court, put the clock back on. We are ready for trial. And the point of this is just to say how important it is to understand that the government can't just hold people in limbo, that the right to a speedy trial is to the defendant, and that it is an option for people to make the government get moving if they're not moving and dragging out a case. You already know it, guys. You already know it. Even if there's a continuance, even if there's a speedy trial notice, defendants are innocent unless proven guilty. So all throughout all of this stuff, that person is innocent. So pretrial work is over. Now what happens? Back to those branches we talked about in the beginning, really trial, plea, or the case gets dismissed or dropped, right? Those are really your options at that point. You know, the charges have been filed. You've been working up the case. You either go to trial, you take a plea, or the case is dismissed. So here I want to talk a little bit about criminal case dispositions. These are sort of your general dispositions, and we'll go through each one. First, very quickly, I might as well talk about your case being dismissed or your charges dropped. The first thing I want to say about that is it is unlikely at the point that, you know, the case has been worked up, and it's unlikely, but it happens. People recant, alleged victims recant, evidence comes out that the elements are not proven. It happens. Like, for example, I had a person experiencing homelessness who was accused of brandishing a weapon at an officer, and turns out that when I was doing the deposition, the officer said that he was not afraid of my client when my client was brandishing the weapon at him. And why is that relevant? Because in order to prove a assault, there needs to be fear on the part of the alleged victim. So I was able to, after depositions, after charges were filed, after investigating the case, file a motion to dismiss that resulted in the case being dismissed. Conditional null process can happen, meaning the state can say, test negative on your drug test for 6 months, and then we'll dismiss your possession case. So a conditional null process can happen. And I want to say that a no action is not synonymous with a not guilty. So not guilty only comes by way of trial. If the state dismisses your case just because they dismiss your case, doesn't mean you're not guilty. Let me see. Thank you for asking that question. And then I read in the chat, what is the difference or significance between a no file and a null pros? Great question. So a no file is just charges were never filed, right? Like arrest was made, charges were never filed. A null pros is charges were filed by the state, formal charges, but they were later dismissed. So if the state just never files charges, they just never filed charges. That's it. But if they did file charges, the state then has to retract those charges if they are going to dismiss them. And they do that in the form of a null pros. To kind of expand on that question, there's also a no action. That's in your felony cases, it's the same as a null pros. But if the state files charges and later decides to take them away, they have to null pros or no action them. I hope that answers the question. And they can refile them later if they want. Okay. So I'm going to keep going faster because I'm just talking too much. I know we have a little panel coming up soon with Cindy, but competency status, that's sort of a second disposition that I wanted to talk about. Competency status, because it can result in a dismissal. Just very quickly, the defendant's competency is incredibly important throughout a criminal case. And when the defendant doesn't have the sufficient present ability to consult with their lawyer and actually help themselves in their defense, it's possible that they don't understand the process and the procedure and what's going on around them. I've had clients who think that the prosecutor is their friend, or I've had clients who cannot recollect what happened to them due to very serious mental health, episodes. All of those things are incredibly important because a person who is incompetent to proceed cannot be forced to stand trial. And I just kind of put the process on here that, a defendant can be incompetent for many different reasons, whether that's intellectual disability, serious mental health, and competency can be raised by either party. The defense can raise competency, the judge can raise competency, the state can raise competency. If competency is raised, doctors do evaluations, and if there is a consensus, that person goes into restorative services if they are eligible. So competency, what are the experts considering? Whether the defendant can appreciate the charges or allegations against them, appreciate the range and the nature of possible penalties, understand the adversarial nature of the legal process, disclose facts to counsel so counsel can properly investigate their case, manifest courtroom behavior, of course, and testify relevantly. And in this next slide, I just want, why is it a disposition? Why is competency a type of disposition that happens? If a defendant is found incompetent, they can go to restorative services. And if they are restored to competency, they can be tried for the case that is against them. But if the person cannot regain competency, it ends up becoming a dismissal without prejudice, so the state can refile, based on the fact that this person's not competent. And I put here, the relevant rules, misdemeanors, felonies. Most important, in my opinion, to note is that if somebody has an intellectual disability, they can never be restored to competency, and their case will be dismissed after 2 years. If somebody remains incompetent for 5 years continuously after being tested over and over again and taking their medications, still not getting it, still not understanding what's going on, the case will be dismissed after 5 years. You may be asking, how can somebody be competent and not be competent? An example would be someone who becomes medicated. Maybe they have a very serious mental health issue and they take, they are not medicated and they become medicated through their restorative services. Then they finally know, oh, I am being charged with this. I do remember this, or I can assist with this. I know who the judge is. That would be like a regaining of competence. And I just do want to say, beware of voluntary and involuntary commitment. So just to put that out there, raising competency is very serious, but you have to do it sometimes, because if your client can't appreciate what's going on around them, you cannot force them through the criminal justice system and do everything for them, because their express desire is paramount when it comes to criminal cases, because of the devastation of the loss of their liberty if the case doesn't go the way that they hope it goes. So people can be involuntarily committed to very scary places while waiting to become competent again, and those places are really just as scary as jails and prisons. So my favorite type of disposition, not guilty. Not guilty only comes by way of trial verdict, and double jeopardy attaches. So if you go to trial, you're found not guilty, that's it. State, you got your bite of the apple. 2 things to note is a not guilty verdict is not expungible. So you go to trial, you are found not guilty, you cannot expunge that from your record. And there are no reparations. You could be waiting trial for 12 years, finally found guilty, been in prison or jail that whole time. No reparations. So here is just a criminal disposition sheet. I just wanted you all to see it. This is after a trial, guilty or not guilty. So if you're looking through court records and you try to pull up a dispo sheet, this is what it'll look like. Every jurisdiction is different, but here's an idea. It's signed by the jury, signed by the foreperson. And it says either guilty or not guilty. Sometimes the guilty has more subsets if there are like lesser included or other charges. So again, all people accused of a crime are innocent unless proven guilty by a court of law. So all throughout, all the stuff we've been talking about, unless that person was found guilty through trial or via plea or whatever, they're innocent. Not guilty. Not guilty. Innocent. Only not guilty after verdict. All right, guilty disposition. Obviously my least favorite as a former, defense attorney. Guilty is a disposition that can come by plea or trial. Where not guilty, you have to go to trial to be found not guilty. Guilty, you can take a plea or you can lose trial. In either circumstance, double jeopardy attaches. So if you're found guilty, that's it. Can't be tried again for that same charge, same criminal episode. Court costs and administrative fines are usually mandatory with all convictions, I won't say convictions, because we're going to talk about that, but all guilty dispositions. And can come with restitution or a criminal order of restitution. If you want to know what that is, drop it in the chat. I'll answer it later. But ultimately, there are 2 types of guilty dispositions, okay? So we went through guilty at trial, I'm sorry, not guilty at trial. Now we're talking about guilty either via plea or trial. Yeah, this slide is out of place. But so real quick, when we're talking about trial, things that I wanted to note are outcomes of trial can be not guilty, guilty, or mistrial, common mistrial. The burden of proof at trial is beyond a reasonable doubt. The burden is solely on the state, the government. Criminal defendant has nothing to prove at all at any point in their trial. If they wanted to sit and play cards or play on a phone the entire time during trial, they can. They have no burden. Important thing I wanted to say is the right to remain silent versus the right not to testify. So going back to the fact that the burden of proof is solely on the government to prove a criminal case, when we talk about a person's right to remain silent, that kind of gives the term undue justice. Criminal defendants don't have the right to remain silent. They have the right not to testify or be a witness for the state. So I know it sounds like a nuanced difference, but because the state has the full burden to prove a case, if a defendant chooses not to testify and become a witness in their own case, it should not be viewed as they're staying silent, they just don't want to tell us what happened. It should be viewed as that defendant exercising their constitutional right to make the state do what they're supposed to do by the Constitution based on their evidence and their witnesses, not something that the defendant might have to say. So that's, just my little 2 cents there. Pleas. So there's a couple different types of pleas. You have your plea from the state attorney. You have your defense counteroffer, which is a plea from the defendant. And you have an open plea to the court. That's really where pleas can come from. The state can give them, the defendant can offer them, and the court can give them. So this is the scary stuff, right? Adjudication versus adjudication withheld. So if you're found guilty, whether that's by trial or by plea, doesn't matter. You can either be adjudicated with a conviction, or you can have a withhold of a conviction. Why is this important? So an adjudication is a finding of guilt and an issued conviction. What does that mean? That means convicted felon. Everything that you think about with convicted felon comes with an adjudication. And I put there the chapter that applies, and I put there, some crimes require an adjudication, but it's simple. Adjudication, convicted felon. Now, withhold of adjudication is a little more nuanced. Withhold of adjudication is a finding of guilt. The person is guilty. They've either been proven guilty at trial or they took a plea and they are guilty, but a withholding of that conviction. I know it's frustrating, but ultimately, with a withhold, the person does not become a convicted felon within the traditional understanding of what happens with a convicted felon. What I mean by that is a person with a withhold. So let me see quickly. I'm going to try to go to the next slide, but this is really what you need. A person with a withhold has no conviction for the purposes of job applications, credit, housing. They can maintain their right to vote. They maintain their right to own firearms. They can still serve on a jury. That charge cannot be used to impeach them. It affects their driver's license in a positive way. You can actually seal and expunge withholds. You can't seal and expunge adjudications. Certain enhancements. I know that's a lot to talk about with enhancements and things, but long story short, a withhold is so much better than a conviction. And it does make a difference, not in what happened with the criminal case, but in the implications of the conviction on the person. And so while a withhold of adjudication does not count as a conviction, it will still appear on a person's criminal record unless they get that record sealed after or expunged after the conclusion of the case. So I know this is like a really tense topic for people who are not in criminal court to understand, but I'm going to say it again. An adjudication and an adjudication withheld are the same thing when it comes to what happened with the criminal case. Guilty, done. It's a guilty. The difference matters with how that conviction functions outside of criminal court, how it affects the person's rights. And when a person is adjudicated, they are a convicted felon for all intents and purposes. When it is a withhold of adjudication, the person's rights remain intact, and there are many, many benefits. Essentially, when they go for a job application and they're asked, were you convicted of a crime? The person with a withhold of conviction can say no, but the person who was adjudicated has to say yes, because they are a convicted felon because they were adjudicated. All right, I'm going to quickly look at the questions here because I think they're really relevant. And I can't even tell you how much more I have to share with you all. I have I don't even know how many more slides. So I might let Cindy come in and do her discussion and just keep talking to whoever wants to hang around afterwards, but you'll get the recording no matter what. I'm so sorry. I want to talk about this forever. Okay, so quick questions. Can a person that got a not guilty ruling at trial still file a petition for expungement and sealing? Okay, or are they completely barred from even filing? So person with a not guilty, if they went to trial, found not guilty, cannot file for any expungement. They are not eligible. It is only eligible for withholds on certain types of crimes. So not guilty, on your record forever. Under what circumstances would a withhold be offered versus an adjudication? Great question. I'm gonna quickly pop back here. Okay, so going back to this slide, again, the question is under what circumstances would a withhold be offered versus an adjudication? So not all crimes are eligible for withholds, like your life felonies, your first degree offenses. They're usually for more, I don't know how to say this without sounding, my criminal defense-y, but for less serious crimes. It's in the court discretion. So there are some factors that talk about, reasonable justification for them, and that would be 921.0026 if you want to look at some factors. But really, it's offered often for first-time offenders, and there are limitations on them. So you can only have, I think, 2 withholds. I think I wrote it there, no adjudication. Yeah, 2 or more. So you can't have more than 2 withholds on your record. Sometimes it happens, the state and the judge agree, everyone agrees, and it happens, but that's rare. It's often for charges that are not as serious. And then some courts really, and first-time offenders, and oftentimes courts do consider how it affects housing or jobs, and the state will consider that too, and so sometimes they offer it based on life circumstances, if it would really make a big difference for career. Truck drivers sometimes have issues with that, getting their licenses and things. Okay, awesome. So I'm going to quickly take a stop here, and I'm going to see Cindy. Are you on? Did you hop on? Let's see.
Yes, I did.
Hey, Cindy, how are you?
I'm fine, thank you.
I am running very behind on my presentation because this is a topic that I really enjoy talking about. But I know you have limited time. So I thought maybe we could move over to your portion of things, and I will come back, to my portion and finish out with whoever has the time to stay on. What do you think about that?
That sounds great to me.
All right, let me quickly stop my screen share. Let me see, give me a second. All right, so, and let me also, this is me, I'm hosting and I'm speaking. Okay. And folks should now only see me and Cindy, if that is correct. If y'all could let me know in the chat, that would be great. And then I'm going to turn it over to you, Cindy, to introduce yourself a little bit and talk about all of the expertise that is why I wanted you to be here.
Well, thank you very much. I'm Cindy Huddleston. I worked at Legal Services for decades before coming to Florida Policy Institute about 5 years ago. So now I am purely in the policy analysis. That's what I do now instead of litigation. But I do try to keep up on a lot of the SNAP policies. And one of the things that we're really interested in at Florida Policy Institute and have been working on is some of the SNAP policies and laws that limit the eligibility of people who have criminal convictions. So I'm very happy to be here today and try my best to answer whatever questions you may have. And if I can't, I will definitely look into it and see if I can get the answers to you.
Awesome. Thank you so much, Cindy. I always love working with you. For those of you who haven't seen the Snapped Up, that's one of our best series that Cindy was a part of. And so I'm looking at I have multiple screens up here, so please forgive me, everybody. But, Cindy, let's start out. And actually, before I start out with the questions, I just want to let everybody know, I intend to sort of have training going forward, exploring the intersections between criminal law and the clients that we serve. This is the first one where we're going to have this discussion. We're going to move into housing, sometime in December. We're going to move into immigration again. So this is my goal is to get you all immersed in different parts of criminal law intersection. So Cindy, first and foremost, what are the most common benefits affected by criminal convictions? And how do those convictions impact eligibility?
Yeah, well, SNAP and TANF are probably the safety net programs where criminal convictions are most likely to affect eligibility. And for those of you who don't know what SNAP is, and most of you probably do, it's a food assistance program that pays monthly grocery assistance to families with low income. It's what used to be called the food stamp program. And TANF is a cash assistance program. It's very small because of rollbacks in that program since 1996. But it provides monthly cash assistance, very modest monthly cash assistance to families with children. For example, the most TANF you can get if you're a family of 3 and you have absolutely no other income is $303 a month, which of course doesn't go very far to meet the needs of your children. But those are the two programs that are most impacted by criminal convictions. But one thing to keep in mind is that studies show that these programs are really invaluable in protecting low-income families, particularly households with children and seniors, who make up a big portion of Florida's SNAP caseload. Also, fraud, which may lead to a criminal conviction, but doesn't always lead to a criminal conviction. It can be done administratively, an administrative finding of fraud. Fraud is really very limited in both SNAP and TANF. The federal government provides, significant oversight of the program's accuracy and fraud detection and prevention systems. And these strong systems really do go a long way to ensure a very high degree, of integrity and accuracy in the program. But to answer your question, first off, jail time is always a possibility for convictions of public assistance fraud, and I won't keep repeating that. But there are also other significant penalties that may disqualify people from safety net programs, even if there is no jail time or criminal conviction. For example, program violations related to the use of SNAP involving the sale of a controlled substance can get people disqualified permanently the second time that it happens. For violations relating to the use of SNAP involving the sale of firearms, explosives, or ammunitions, the disqualification period is permanent for the first violation. And in addition to these specific program violations, there are also 3 situations in the SNAP program where an individual convicted of a crime is automatically disqualified. 1, when they are violating probation or are a fleeing felon, and that is defined as someone who is fleeing to avoid prosecution, custody, or confinement after conviction for committing a crime or attempting to commit a crime, that's a felony, under the law of the place where the individual is fleeing. 2, if they have a felony drug conviction after August 22nd, 1996. Or 3, if they have a felony conviction for aggravated sexual abuse, murder, sexual exploitation of children, or an offense involving sexual assault, but only if the person is not in compliance with the terms of their sentence of probation and the crime was committed after February 7th, 2014. So there are a lot of, moving parts having to do with TANF. With SNAP, I'm sorry. It's very similar for TANF. In general, disqualification periods for fraud in the TANF program include a permanent disqualification for the third violation, but there are also other situations that can cause permanent disqualification. For program violations that involve the trafficking of TANF benefits, the disqualification period may be permanent for the first violation, depending on the amount of TANF involved. In addition, like SNAP, there are situations where an individual convicted of a felony is automatically disqualified from TANF. This would be if they're a fleeing felon or violating probation, or if they have a felony drug conviction, if the conviction occurred after August of 1996. So I think that kind of answers your first question.
It definitely does. My gosh. Let me see if I can pull up, because I'm on 1,000 different computers right now. I have 3 different screens up. And so, I know one of the things that I wanted to ask you while I'm looking at this, I'm jumping around, but, how can, legal advocacy make a difference? How can it work to change that trajectory for people who are shuffling through the criminal justice system and help them have better access?
Yeah, legal aid programs, play a huge role. And many times, felony disqualifications, for example, are wrongly applied. And unless someone gets legal help, they may never be rectified. Sometimes the case can be fixed with a phone call, but sometimes you need to go to a hearing or really be very persistent with your advocacy with DCF. And so legal aid programs are really on the front line in doing that for folks. And just to say, if anyone has an issue with any of these, any of your cases, if you want to reach out to me, if you have a case and want to brainstorm, I would be happy to brainstorm about ways you might be able to go about trying to fix the problem.
I'm on mute. I said, awesome. Thank you. So, another question that I had up here is kind of bouncing back, remedies. So, what legal remedies or options do people, experiencing these criminal convictions who are denied their public benefits, what legal remedy options do they have?
Well, DCF has appeal procedures, which are called fair hearings, where people can, formally contest the decision that DCF has made in their case. And this applies to a lot of the disqualifications that the department applies to people who have felony convictions and other kind of criminal convictions. And it's not just an effort in futility. Many times there are really ways that you can show that the disqualification or penalty has been applied incorrectly to someone. For example, just because someone has a felony drug conviction doesn't mean that they are disqualified. It has to be a drug trafficking conviction. Also, someone who can contest their permanent disqualification for drug trafficking if the conviction was on or before August of 1996. And those are just 2 of the low-hanging fruit ways to kind of contest these disqualifications, but there are many ways to do that. So many ways that decisions can be made incorrectly, and so it makes sense to really review the case to make sure that the disqualification is done properly, and always to do an appeal if there are ways you have to be able to argue that it's incorrect.
And, I think the last of our questions that I wanted to ask you, and I'm saying that for folks, if you want to add any questions particular to Cindy, in particular this topic of public benefits, please drop them in the chat. I'll make sure to read them out loud. And I know this is something that we all know very, very much, but I think it's always worth, discussing about, what are the types of challenges faced by, individuals with convictions, with public benefits, reentering society. I'll say, just on a logistical thing, you're the policy.
Yeah.
On a logistical thing, I know I've dealt with clients who they have benefits, they become incarcerated, they're incarcerated for a certain amount of time. they lose their benefit, they don't get noticed because they now are somewhere else, they don't, and now, or someone's been in prison now for X amount of years and need to come out, need to restart their benefits, don't know how. Like, I mean, just on those practical levels,
Yeah.
That happens more than anybody really can say. But also in your opinion and expertise, what do you see?
Well, we see those things. I think the short answer is that when people who have been incarcerated return home, we all know that they face, enormous roadblocks to economic mobility. They have to find housing, transportation, food. They have to look for gainful employment, which is often a struggle because of stigma and occupational licensing restrictions that may impact their ability to return to jobs that they were used to doing in the past.
Yeah.
So they often are rely on safety net programs until they get back on their feet, to eat, and if they have children, to take care of their family. So that's why it's so important to make sure that their eligibility is determined correctly. And I did also want to mention that it's interesting. There was a study that was done several years ago on Florida's ban on the SNAP eligibility of people with felony drug convictions. And it shows that that ban increases recidivism and ends up costing the state more in the end. The bottom line is that lifting that ban would reduce the chances of reincarceration. It would help, as we all know, help everyone with a smoother transition back into their communities. And surprise, surprise, there was some study that went in to show that it really does save millions in taxpayer dollars, which is another reason why it's important that Florida, look again at this ban. And believe it or not, this is something that other states have started looking at and repealing. So a lot of other states have already repealed similar kind of bans on felony convictions for SNAP and TANF participants. Florida has not. 2 years ago, there was a bill that was introduced in the legislature that had bipartisan support, but never got a hearing in the committee that it was in. This year, we are a little more optimistic that a bill is going to be filed in both the House and the Senate, and we're really hopeful that it has some traction. This session, as it has in many other states, both blue and red, realizing that it is a policy that does not make sense at all.
Yeah, absolutely. Wow. Thank you for sharing that. And did you say that it was a particular study that you referenced? Is that something you can send over to me? Maybe
Absolutely. Yes. It was a study done just on Florida's SNAP felony drug ban. It's very persuasive. It's what we've been able to use with legislators to be able to get bills filed in the past. And we're hoping it's going to help take us over the finish line of this session, as well as any support that we can get from programs or people who are interested in having their voices heard about that issue.
Awesome. Well, I would love to be able to share that with everyone as a resource. Thank you for mentioning it. And this was just going to be a quick discussion. I know you have things to get to, and I have another I think 15 slides for people who are willing to stay on with me. So, with that, Cindy, thank you so much for joining me, and thank you for opening up this discussion. It was actually the perfect timing, because now that we're done talking about types of convictions, I'm going to move into jail and prison and sentencing. So this was kind of the perfect little segue and break that we needed. Thank you, Cindy.
Well, thank you very much, Alexis, and thank you, everyone.
Always a pleasure to work with you. I'll see you soon.
Thank you. Bye.
All right, folks. Well, I am going to reshare my screen, and whoever, can stay along, please feel free. I definitely, just have too much that I want to share with you all. But like I said, it is going to be recorded. So this is being recorded, not going to be recorded. It is recorded. And if you have to hop off, I'm just going to keep talking, even if it's to an empty room. So you will receive a copy of the recording and you won't miss a beat. So let me get my presentation back up for those of you who can stay. And we're jumping right back into the atmosphere, back to our withholds and our adjudications. So, oops. All right, we talked about those benefits. Yes, nolo contendere. So back to where we were in this conversation, we're talking about guilty dispositions which can come by way of trial or plea and can be adjudications or withholds. Okay. Now, nolo contendere is also known as no contest. It's Latin for I don't wish to contend, and it accepts guilt but doesn't admit guilt. And if somebody does plead nolo contendere, the judge can either adjudicate the person or find an adjudication and withhold the conviction. I've only dealt with nolo contendere in a few circumstances where clients just really did not want to accept the facts. And that might have had to do with a perceived effect in a collateral case. For example, maybe a domestic violence issue that happened in a housing situation where it's landlord-tenant and they don't want to admit certain facts because they are afraid it will affect another case. Also, sometimes people with some serious mental health have issues, accepting facts, and I mean that only in the context of their case, not necessarily life. So this is just niche, but worth mentioning. Okay, so proven guilty by a court of law, what happens next? Spoiler alert, you're probably not going to see my slide about innocent unless proven guilty anymore. We're in the world of guilty here. Sentencing. So sentencing in Florida can be probation, community control, jail, or prison. Just to give you some understanding of the differences between jail, prison, misdemeanor, felonies, probation, community control, all of these ridiculous terms. Your misdemeanors, you can have first degree or second degree. Misdemeanors are punishable up to 364 days in the county jail. So if you see somebody who has on their criminal history, that they've been, incarcerated for, 5 years, it's likely, one, it's not a misdemeanor, and two, it's likely a prison sentence, but we'll get there, but it's not a misdemeanor. Misdemeanors are only punishable up to 364 days in the county jail, max. Second degree misdemeanors are punishable up to 60 days in the county jail, max. A person can be placed on probation in a misdemeanor case, and the probation would not exceed these timeframes. So probation for 60 days, probation for up to 364 days. There can also be combinations. Somebody can be put in jail for 64 days and on probation for 300 days, but that's sort of the idea. Felonies, you have 3 degrees. You have first, second, or third. For a third degree felony, up to 5 years in the state prison. Second degree felony, up to 15 years in the state prison. First degree felony, up to 30 years in the state prison. You have your life felonies, PBLs, punishable by life. Your capital offenses, which are obviously death penalty eligible offenses. And again, a person can be placed on probation, community control, a combination not to exceed these timeframes. It can also include, jail, probation, not to exceed these timeframes. So disclaimer, I don't know that I put it in here. I put it in going forward. These are the standard in felony world, not talking about misdemeanors. Misdemeanors are pretty simple. In felony world, these sentencing structures are the baseline. Someone with no priors picks up a third degree felony, can face up to 5 years state prison. Now, if you have priors or open cases or different factors, you can face more exposure. So this is envisioning more of a closed universe where this is the baseline of generally what a third degree felony is, generally what a second degree felony is. And, we'll talk more about this. Probation versus community control. What is probation? Probation is court-ordered supervisory condition for persons convicted of misdemeanors or felonies. It can be in lieu of an incarcerative sentence or after. And it can be standard, reporting, administrative, non-reporting, drug offender probation, sex offender probation. So there's different types of probation. They all come with different types of things that a person has to do. Overall, it's a form of community supervision. Now, community control is also known as house arrest. it's a more restrictive form of supervision than regular probation. It's only eligible in felony cases. You cannot be put on community control in a misdemeanor case. Again, it's either in lieu of an incarcerative sentence or after, and it's much more restrictive than probation. It's essentially probation plus house arrest. Usually requires a GPS monitor, curfews, inability to leave the house, all of these things. So it is a step down from prison, but it is an extremely, extremely controlling environment, obviously. So probation and community control. Did I miss a slide? Let me double check. Yes, I did. So probation and community control, some commonalities. Florida Statute 948.03 was what applies. Both probation and community control can be terminated early if a plea was silent to early termination or embedded into early termination. What that means is the plea can say 5 years probation to be completed, early terminated at 2 years if the defendant tests clean on a drug test for 6 months, or for 2 years, or I don't know the math, but you can embed early termination into a plea agreement. Probation is very costly. Again, we talked about that house arrest. I didn't mention, but there's also a cost of supervision, and that applies to all people, including people who are, living and experiencing poverty. They are required to pay their cost of probation. If they don't pay their cost of probation and can prove an inability to pay, they will not be arrested. Well, they can be arrested for it. They will not be violated for that. But at the end of the day, there is a cost of supervision attributed to all people who are on forms of supervision. Non-compliance with the terms of probation can be very serious. It can result in revocation, extension, and the cycle of incarceration. You have technical violations, substantive violations. What does that mean? A technical violation could be missing your curfew, not doing your community service hours. A substantive violation is usually like a new law violation, meaning you got arrested again while you were on probation. And this is kind of important in a lot of ways, but also to know that when you are on probation and you violated probation, a probation affidavit will get filed, and that will toll your probationary period, meaning it's not going to count during the time that you're on probation. So while the court is trying to figure out if you violated your probation, you're still on probation and not getting credit for being on probation, which can then extend your probation. And the legal standard at a probation violation is a willful violation by preponderance of the evidence. Hearsay is allowed, but a violation cannot be solely based on hearsay. The burden of proof is on the state, and the state can withdraw a probation violation. They can say, never mind, we say he violated probation, but she violated probation. We decided, never mind, we don't want to punish them for that. So you are on what we call a fishing line. When you're on probation, you're reeled in, cast it out, reeled in, cast it out. It is really, really tough. So that's just stuff I wanted to mention about probation. Just those takeaways, that it's very serious restriction, very hard for people to comply. Imagine people experiencing homelessness. Unfortunately, I've found that people experiencing homelessness are actually not even offered probation because they, by virtue, cannot comply, because you have to report, you have to stay in contact with your probation officer, you have to have a residence usually to let your probation officer know where they can supervise you. And people who are experiencing homelessness often just get offered, jail time, more jail time, because they just can't comply with probation. So quite unfair, and it happens often. But then putting someone who is homeless on probation just results in continuous violations, for just their life circumstances, which is also unfair. So revocation, just something important that I really want to mention here, is that probation, I said, it can be extended, it can be early terminated, it can be revoked. And revocation is really important because if probation or community control is revoked, the court is required to impose any sentence it may have originally imposed before placing the petitioner on probation or the offender into community control. Why is this important? So assuming somebody was on was charged with a second-degree felony. We saw that that is punishable up to 15 years in the state prison. Let's say they're given, 5 years of probation instead of the 15 years in prison. Essentially, if they violate their probation and the court decides that they want to revoke their probation, that person can face up to any sentence it might have originally faced, any sentence that person might have originally faced before being put on probation. So we're talking about a second-degree felony punishable up to 15 years. That can just, again, now all that prison time can be assessed to somebody that was on, supervision. So it's really, really serious. Probation is not just a luxury. It's not just something that you just, that doesn't matter. So quickly, I just wanted to also show you all a disposition sheet. Again, this is all redacted, and this is a disposition of probation, and it shows what the person's supposed to be doing. You shall not change your residence of employment without consent. You will make truthful and full and truthful reports to your counselor at a minimum once per month. You will remain at liberty without violating any law. You will not use intoxicants. Ooh, this person couldn't use intoxicants. I just wanted to show you this so you can see this is what an order of probation will look like. So if you're not sure if a person is on probation, but you see something like this means that they're on probation. And I also wanted to show that in this circumstance, there's a little special circumstance here: no violent contact with the victim, substance abuse and evaluation and applicable treatment. Hint, hint, usually they always say you need treatment. Same for mental health evaluation and treatment. And so even though these are not fully developed within the requirements listed in this probation order, these are additional things this person needs to do in order to stay out of jail or prison. Which brings me to the next conversation of jail versus prison. So jail is your conviction with a sentence of 364 or less. It's county time. This can apply to misdemeanors or felonies. And there are some people who, even if they're charged with a felony, will score what's called mandatory non-state prison, which we're going to talk about going forward. But I just wanted to put that out there. And prison is a conviction with a sentence of 366 days or more in a state or private prison. When you go to prison, you get a prison number. Although you can actually, this is sort of the similar conversation to the promise to appear that we talked about way back when in the beginning of this conversation. But you can actually get a prison number without ever serving time in prison. I've had it where I've had clients who are about to get out on a 364. The state decides that they want a prison number out of the person. They agree to 366. They get transferred basically to the state prison. They get booked under a prison number, and then they're released into the community. So sort of like that idea that someone's like, well, I've never been to prison, but I have a prison sentence. Like, it is possible. Just want to put that out there for those of us who don't practice in criminal law to know that, your client, if they talk about this, isn't lying necessarily. Prison only applies to felony cases. And then this is a lot, but when we talk about prison, things like minimum mandatories, which are day for day sentences, enhancement, habitualization, all these funky terms, VCC, perp, GORT, weapons, all these things happen in felony cases when prison gets involved. And what I'll explain about that just very quickly is, for example, a minimum mandatory. A minimum mandatory is when a charge is punishable by a certain amount of time in prison. And the Florida legislature via statute has said that for that crime, the person must serve every single day of that prison sentence, day for day, no gain time. An example would be your firearms charge. So if you're a firearm convicted felon and you're found guilty of having a firearm, there's a minimum mandatory, I think it's 3 years, that you have to serve day for day, no gain time, day for day. That's just an example of these terms. If you want to know more about these terms, please feel free to reach out to me because we could talk for hours just about all of these. But VCC is a violent career criminal. Fun fact about that is burglaries, even if it's completely unoccupied vehicle, can make you a VCC, which has huge implications to your liberty. Perp is usually someone who was someone who had a prison number. That's why I say that it could be someone who served time in prison or had a prison number, and got arrested again within a certain amount of time being back into the community, or convicted, I'm sorry, is a perp. And you just have all these nuances, which are so fun to talk about. We don't have the time. So sentencing, what's my score? What is the court considering? The court is looking at, and if it's in felony cases, the score sheet, score sheet is not a thing in misdemeanor. And I have a score sheet. I'm going to show you a score sheet. So the court is looking at your priors, statutory requirements. Like I said, convicted felon in possession of a firearm has, statutory requirements. Aggravating factors, certainly looking at those, and witness impact statements. And so the court's looking at all of this when deciding sentencing. And I'm going to stop again, because I know we have been a little discombobulated in this training. Where we are is we are at the point that somebody either went to trial or took a plea. They were found guilty. They were either adjudicated or their adjudication was withheld. Their conviction was withheld. And they're being sentenced by the court. Okay, just want to be clear as where we're at, because we've talked about it a lot. So I think from the beginning of this training, nobody said they were a former public defender or state attorney, but if anyone has had any experience with this sheet, it is the score sheet, and it's a nightmare unless you're extremely good at math. But basically, this is a quote unquote standardized way to assess punishments in sentencing to people who have been found guilty of a crime via trial or plea. Doesn't matter. The score sheet is relevant. And this sheet is actually something that drives the bus when the state and the judge are considering offering pleas to the defendant. Because after filling out all of this sheet, answering all the questions as you see them, what are the offenses? Are there additional offenses? Is there a victim injury? What are the priors? At the end, there will be a number that will say what minimum and what maximum amount of incarcerative time a person can serve. So I just want to have you see this so you know it. So jail and prison takeaways. Credit for time served is up to the court, really, and it must be clearly stated on the record. So if somebody has been in jail awaiting trial and they get out and they decide to take a plea, and let's say they go on probation, but the court never gave them credit time served for like all of the time that they were in jail, and let's say they violate their probation, they're not going to get credit for all of that time they were sitting there waiting. These things to consider. Just credit time served is really important to make sure is set on the record. Gain time is solely within the discretion of the Department of Corrections. So judge, state attorney, nobody else can affect gain time and whether or not you get out earlier than you're supposed to. That's only up to the Department of Corrections. And, important to say, any amount of jail or prison is absolutely traumatic for a person, regardless of their, guilt. Prisoners lose contact with their loved ones. They experience danger when they're incarcerated. They don't receive adequate health and mental health care. I don't care. I'm not even sugarcoating that. They don't. And they virtually have no rights or access to justice while they're incarcerated. So it's really, really important to keep that in the forefront. So quick thing on sentencing, and I think we're at the last few slides here. I did talk earlier about the ability to plea open to the court. I don't know if you remember, I said a plea can come from the state. A plea can come from the defendant making a counteroffer to the state, and then a plea can come from the court. Now, if the state attorney offers a plea in felony cases, I'm talking about now, offers a plea. Actually, in misdemeanor, they can do it too, but there's no score sheet. But let's focus on felony. if the state attorney offers a plea and that plea is below guidelines, what I mean by below guidelines is that score sheet, going back to the calculation they come to here. If they make a plea that is below the minimum amount of jail or incarcerative prison, incarcerative sentence that this sheet requires, then the judge can get involved. And the judge can get involved and say, well, okay, the state's offering you below guidelines. I'll offer you this. It's a little complicated and nuanced, but it's important because it's a driving factor sometimes in the pleas that the state offers. Sometimes the state does not want the judge to get involved because they want a person to serve a certain amount of time for a charge. So they won't offer a below guidelines plea because they don't want the court to be able to offer a different plea. Other times, the state doesn't want their hands tied and they do want the judge to be able to get involved. So they can offer a below guidelines plea and then the judge can make it even better. Long story short, if the state takes away their offer, take it off the table, the court's hands become retied. So I've been there in court where the state gives a below guidelines plea. I say to the judge, how about less, judge? And then the state says, never mind, we're taking the plea off the table. So just something to be aware of. Reading disposition sheets. So everything that we just talked about for a long time were types of dispositions. The competency, dismissal because of competency, not guilty, guilty, which branches down into your adjudication and your adjudication withheld, sentencing. Disposition sheets are what lays out the sentence. And these are different in all jurisdictions. Every jurisdiction has a different look and different. So I can show you this from Jacksonville, but it might look different in Pinellas. You never know. But mainly what I wanted to show you this for was looking at this right now. You can see here, we have a judgment and sentence, and the charge is a battery. And the person pled no low contendere. Now, I won't ask you to, answer in the chat because I think it's too confusing. But so we talked about no low contendere. Now we know what that means. That means the person is guilty, but didn't want to accept the facts. Okay. Now, is the person adjudicated or is the adjudication withheld? So let's see. So here we go. We go down, we go down, we go down. We see that this person served time in prison, you see, or I'm sorry, jail, not prison, sorry, jail. 2 days, 2 days of credit time served. And look, we have here jail time as a condition of probation. And the person was placed on probation for 6 months. And then here we have all the money that the person has to pay as a result of their administrative fines and the guilty plea. Boom, 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 boom. And I think, did I have another sheet? Oh, I might have cut off a sheet. So ultimately, this actually doesn't clarify whether the person was adjudicated or the adjudication was withheld. It actually doesn't clarify that. I probably need to give you a better example, but at the end of the day, that's how you read a disposition sheet. And if you aren't sure if the adjudication was withheld or not, I would continue to go through the clerk of court's docket, and there might be something printed on there. Like I said, every single jurisdiction is different. And just because they don't have it here on the judgment of and sentence, it might be somewhere else on that clerk of court docket, if that makes sense. Okay, which brings me exactly to what I put here, resources. So what can you do to learn more about a person's criminal case? You can check out the electronic court dockets. Believe it or not, as an attorney, you don't even have to be an attorney on a particular criminal case. You can sign up for an account on most of these clerk of court's dockets. And in those accounts, you actually can get access to criminal court records to get a better idea of what's going on in the case. You can also contact the defense attorney or the state attorney's office, However, I do want to say the defense attorney is likely not going to speak with you unless they have express permission from their client. And especially going back to our public defender friends, like they are so busy. They are getting so many calls. The client's calling them. Sometimes the victim's calling them. Sometimes families calling them. So it is the harder route to go, which I recommend maybe like emailing. That might be better. But either way, your client is going to have to provide consent for that collateral communication. And also you can go to a court hearing. I love watching state criminal court cases, but again, that's what I love. But it's open to the public. So let's say you have a client with a collateral criminal case and you are able to go to their court hearing on a day to see what's going on. Go, you'd be welcome. Resources, more cool stuff. The hyperlinks don't work here, but I will send a link to everything. These are just some awesome criminal justice sort of focused organizations that are Florida-based. Fines and Fees Justice Center does incredible work nationally, but they have a Florida base as well, focusing on ending the extreme detriment to life that fines and fees cause people experiencing poverty, low income, homelessness, all of that. It's incredible to see how much the fines and fees associated with criminal justice can just push a person deeper into a hole. So check them out. We also have a training by them that I can send you if you want. Florida Rights Restoration Coalition, doing that really important Amendment 4 work and trying to get voting rights restored for convicted felons. So they're actually going to do a training for us in the next year. Chainless Change, really cool organization as well, more focused in the Broward area, but I mean, fighting things like jail call prices and, issues with legal mail and cool stuff. And the Ladies Empowerment and Action Program, that is a women's reentry and recovery organization from prison pipeline back into society. They're really awesome too. These are just 4 of some awesome organizations that are here in Florida. If you want more resources, you can always reach out to me directly. And that's it. I know we're a half an hour over than where we were supposed to, and I probably ran through some too quickly. But that is, everything that we have today about our criminal law essentials for non-criminal lawyers. And I really hope that, this makes you feel more confident. Like I said, the point, and I'm going to stop my screen share quickly. The point of this training is not to have you go out there and become, a criminal law warrior and change your career. The point of this training is so that when you do have a client that maybe has a criminal case ongoing and maybe wants to talk to you about it a little bit, you're not in the dark. You kind of, probation, community control, bond, pretrial services. You at least will have these buzzwords that make you more competent to be able to have that conversation with them and make them feel heard, because going through the criminal justice system is one of the most traumatic experiences anyone can go through. And being able to sort of like allow people to talk about it and be part of that conversation, even if it's not what you practice, is incredibly important. So with that being said, I'm just gonna, let you all know I can't thank you enough for joining me for this conversation. If anybody wants more on any of these topics, I am happy to come back and do more presentations, more in depth on any part of this that matters to you. And I'm also happy to kind of, talk offline. If something I taught you seems that you need more clarification, email me. Happy to open up the discussion and sort of give you that information if I have it. And so with that being said, the CLE code, remember, is going to be provided at a later date once I receive that approval from the Florida Bar. This recording will come to you all within 24 hours from Zoom. My email address is in the chat if you don't get that email or you just want to chat with me. And join PILS if you can. And so with that being said, thank you all very much for joining me today, and I will see you at the next training.